one of the major reasons that alimony is less prevalent today, of course, is because we have less fault-based considerations. Alimony is less of a punishment, of a retribution. And most commentators would suggest to you that there's less moralism in the determinations regarding alimony. Notwithstanding that sentiment, let me share with you a case that's come out of Missouri recently called Richardson versus Richardson. In Richardson, the husband and wife were divorced in the 90s. They executed a divorce agreement which they agreed that the husband would pay alimony to the wife in the amount of some $2,435 per month forever. This is traditional alimony. Mr. Richardson said, I'm going to pay this to you, excuse me, forever. And he went on further to say it is not modifiable. He went on further to say it's not modifiable under any circumstances, meaning there cannot be a change of circumstances that would authorize a modification of alimony, not by you, not by me. Fast forward to the year 2005. What does Mr. Richardson do? He files a petition to modify alimony. But here's his theory. He says, Judge, I want you to terminate alimony because of the following. My ex-wife sought out a person for the purpose of burglarizing my home. It went further. She also sought out a person for the purpose of murdering him. She failed. The trial court found that there was not a change of circumstances sufficient. He's still alive to make a change in alimony. I'm quoting from Richardson versus Richardson, the Supreme Court, who I can't tell has a sense of humor or not. But in affirming, because it's very dark, it's really not funny, in affirming the trial court's award, the Supreme Court reasoned as follows, and I'm quoting, killing Joseph, Mr. Richardson, might have resulted in the termination of her ability to collect support. But her alleged acts do not establish a clear and unequivocal attempt to relinquish her contractual right to alimony as long as her husband is living. Meaning what they're saying is, you failed, you dummy. But Joseph, he thinks moralism should be part of the alimony consideration. And he cites to the Missouri Supreme Court a number of cases on the following. You shouldn't be able to profit by your own fraud. You shouldn't take advantage of your own wrongdoing. And there's even a Missouri case that says you shall not acquire property by murder. And what the Missouri Supreme Court says, but none of these cases are analogous to the present case. In each of the above cases, the death of the victim was a precondition to the remedy. Joseph says that the state should enact a public policy that discourages murder. And again, I'm quoting from the last line of the Supreme Court's opinion. Quote, this state's criminal and tort laws already do that. He didn't win. In terms of, excuse me, in terms of the topic of child support trust, which you'll find in your materials, let me just tell you briefly about the issue of child support trust. The question arises, is a child support trust legal in Georgia? What do I mean by that? I mean setting something aside for children during their minority to pay child support. Is it legal? We know from the Clark case that you cannot settle an estate upon a minor child in Georgia. Okay? We know that from Clark. But we also know from two other cases that are in your material, the Esser case and the Aycock case, that it is permissible for a court in a trial or by agreement to enter an order directing that property be held in trust during the minority for the purposes of providing child support. We know that from those two cases. And the reason I mention this is in other jurisdictions it's becoming increasingly popular. You see a lot of articles about child support trust. That's a lot of the focal point of negotiation. In other jurisdictions, and I've cited you a bunch of cases, they're increasingly prevalent. And here's the kind of circumstances under which we have child support trusts. cases involving the proven unreliability of the payor parent. Someone that's misleading a court, meaning someone that says, I've got X dollars and they've really got Y. Contempt remedies. You're finding more and more child support trusts being imposed as a contempt remedy. You find them in paternity cases. There's a case in Florida in which it was found to be appropriate because the husband was incarcerated. And my favorite child support case comes out of Wisconsin. In this case, the court found that the payor father was a professional football player. On top of that, he was the team's punter. Doesn't sound like a great job, apparently, to the Wisconsin courts. Child support trust, you're the punter. The question arises, in Georgia, do you have an obligation to seek the remedy of a child support trust by a settlement agreement, by trial, by a contempt remedy? And I would ask you to further query under an income sharers model, would the imposition of a child support trust violate equal protection to the extent that one but not both parents were obligated to contribute? One side would certainly say, well, we've already factored that into the equation. The other side would say that it's not been shown that you are the more responsible parent than I, and it violates equal protection. The last topic I want to talk to you about before we get to the experts is the question of tracing. I think that the question of tracing of assets is one of the most aggravating and difficult concepts in Georgia law. What do you do when the opposing counsel tells you in the context of a case you're just getting started on and your adversary says to you, I'm going to hire a forensic accountant because we're going to do a tracing analysis? What do? I cringe. Why? Under what standard are you going to perform your tracing analysis? Are you going to connect dots? What are you going to do if there's gaps? What are you going to do if, in the typical case, the marital estate zigs and it zags? What methodology are you going to use? Obviously, a reasonable methodology. What do you do if funds are commingled? What do you do if funds have been used for marital and non-marital purposes? Does it make any difference in Georgia? I think we understand the Thomas analysis, the source of funds rule. And as I read Thomas, and you may disagree with me, but as I read Thomas and its progeny, we've adopted a partial source of funds rule regarding a hybrid marital residence. That's what Thomas does. The sole reliance in the Thomas opinion is on a case from the state of Maryland that dealt with a house that was pre-marriage to which marital contributions were made. Remember, in Thomas, the husband also argued, there's two components to this, source of funds, and then you argue appreciation. You see, you argue Thomas, and then you argue appreciation. Was it active, was it passive? And the court in Thomas found that you planting flowers and you painting bedrooms and that sort of thing did not cause appreciation of the home place. We have also extrapolated Thomas perhaps to issues of corporations, and there's also a case that deals with raw land. But I would suggest to you respectfully that our extrapolations from Thomas, both as lawyers and as experts, accountants, are illogical. I would suggest they're creative. I would suggest that they're somewhat comical. And I would suggest to you that they're without legal precedent. I would suggest to you, and we're going to get to this in Nancy and Judge Schuster and David's presentation, that they're junk science, that they're inherently unreliable and should not be permitted. My favorite is the so-called Sweeney case. This is an actual case in Georgia, an unreported decision. This is a young man that